Hi, I'm Attorney Ron Ruskin. In Ohio, you can file for divorce yourself and without a lawyer. This is known as pro se or representing oneself. The legal fees of lawyers can be rather high, and many people are trying to file their own papers. It can be a frustrating process, and often you don't get it right. What if you don't want to do the papers yourself or pay the high price of a lawyer? You and the lawyer can agree that the lawyer will only perform certain services. The lawyer interviews the client and prepares the papers. The client files them, and the client goes to the final hearing without the lawyer. This is a way to greatly reduce cost, but still have the benefits of a lawyer interviewing the client, answering questions, and preparing papers. The most common pro se cases are where husband and wife can agree on the terms of the divorce. There are two types of divorce by agreement. First, there is the dissolution of marriage. This is where both spouses petition the court to dissolve their marriage according to agreed upon terms. A petition for dissolution of marriage is filed along with the separation agreement, which includes all the terms of the dissolution and how all property and debts are being divided. In a dissolution of marriage, both the husband and the wife must attend the final dissolution hearing. Both say to the court that they are unable to resolve their differences and that they wish their marriage to be dissolved according to the terms of their separation agreement. The final hearing in a dissolution of marriage is set a minimum of 30 to a maximum of 90 days from the date of the filing of the case. Second, there is the uncontested divorce. A divorce complaint is filed by one party, but a waiver is signed by the other party, waiving service of the divorce papers, and consenting to the matter being set for a final divorce hearing. Both parties sign the judgment for divorce, which includes terms which have been mutually agreed upon. The uncontested divorce can be granted upon the basis of incompatibility or upon the basis that the parties have been separated for more than 1 year. An uncontested divorce is used in cases where the parties still reside together and cannot file a dissolution of marriage because they have not separated, or where one spouse either does not want to go to the final hearing or cannot go to the final divorce hearing. There may be situations where one spouse lives out of state, is in the military, or just does not want to miss work, or does not want the additional emotional turmoil of attending the final hearing. At the final hearing, a witness vouches for the basis for the divorce. This can be any adult and can be a friend or family member. The person just must say that the parties are incompatible or that they have lived separate and apart for more than 1 year. The final hearing in an uncontested divorce can be no less than 42 days after the filing of the case. In either a dissolution of marriage or an uncontested divorce, there does not have to be any discussion of the marital problems of the parties or getting into issues of neglect of duty, abuse, abandonment, or cruelty, as may be the case in a contested divorce. What are the requirements for residency in Ohio? In a dissolution of marriage, one of the parties must be a resident of Ohio for at least 6 months before the case is filed. One of the parties has been a resident for more than 90 days in the county where the case is filed. In a complaint for divorce, the plaintiff must be a resident of Ohio for at least 6 months before the case is filed. Either party can be a resident for more than 90 days in the county where the case is filed. In the case of a person who lives in Ohio but not for the required 6 months, papers can be prepared but not filed before the 6 months is up. As an alternative, a person can file for legal separation, which does not require 6-month residency, and later convert the case to a divorce after the 6-month residency. Where the parties were married is not important. It is where they reside which determines where the case is filed. Many judges require that papers be notarized, and since required affidavits must always be notarized, it's just a safer practice to have all documents notarized. You should make the number of copies your county requires after they've been signed and notarized. The one exception to this is the final judgment entry for dissolution of marriage or the final judgment entry for divorce. They're not notarized. Court costs are paid when the case is filed. The amount varies by county and sometimes it's different whether a dissolution or divorce is being filed and whether or not there are minor children. If you have no income or assets, you can get the court to waive court costs by filing an affidavit of poverty. Some counties require that pro se papers be approved by a member of the court staff before they are allowed to be filed with the clerk of courts. Others require that papers be approved before the final hearing. A magistrate or judge will not hear a case unless it is verified that all papers have been properly prepared and that all required forms have been completed. The case must be ready for final hearing. For more information about divorce and dissolution of marriage in Ohio, visit my website, Dissolutionohio.com. If you want to save money and file your own dissolution or divorce, but want your questions answered, the process explained, and your papers properly prepared, I can help. I do a full interview by telephone, prepare and email your papers, and do a follow-up by telephone to make sure that your papers are correct and to answer any questions that you may have.